This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to the Bloomberg Law Intellectual Property Review. I'm Josh Block. Coming up, we'll look at a recent ruling in the copyright infringement lawsuit against BitTorrent users accused of reproducing and distributing adult entertainment films. But first, we'll review some recent IP developments reported by Bloomberg News. Amazon.com won an appellate court ruling in a lawsuit over patents for one-click shopping and customer feedback procedures. Cordance Corp had initially sought more than $84 million in damages for infringement. The U.S. Court of Appeals for the Federal Circuit reinstated a jury verdict that Cordance's patent claims were invalid. When Netflix announced they would split their mail-order DVD business and their video streaming service, one thing they apparently forgot to do was nail down the rights to the new mail-order service name Qwikster on social media networks. Not until the day after the announcement did Netflix apply to trademark the Qwikster name. However, @Qwikster was already a Twitter handle and, thanks to the announcement, the handle now has thousands of new followers, 11,491 total at last count. No word yet on whether Netflix will acquire the @Qwikster handle. University of Michigan, Indiana University, Wisconsin, University of California, and Cornell. No, it's not a new athletic conference. These are all universities that have been named as co-defendants in a copyright infringement lawsuit. The schools had been planning to release to students and faculty 27 digitally scanned books believed to be orphan works that Google had scanned for them. The lawsuit claims that the scans were unauthorized and the works still protected by copyright. Michigan has now acknowledged that rights holders for these believed orphan works have been identified. Some BitTorrent users can breathe a sigh of relief, though they may not even know it. Persuaded by a growing body of case law in the Northern District of California, the same magistrates severed and dismissed all but one of the John Doe defendants in mass copyright infringement actions against alleged users of the peer-to-peer file sharing protocol. I'm joined now by Michael Dunn, an editor of Bloomberg Law's Intellectual Property Law Report. Michael, for the uninitiated, will you explain how BitTorrent works?
Sure. BitTorrent is a peer-to-peer file sharing protocol, but it's different than some of the earlier peer-to-peer systems that people may be more familiar with, like Napster and things that were in that generation of file sharing. BitTorrent essentially operates by everyone who wants to download a particular file will have to locate what's called a tracker, which is a piece of software that identifies that particular file. And then through what's called a BitTorrent client, which is a software program that basically will search and operate within the BitTorrent context, you input the software code, the tracker, into the client, and then it locates people who have the file that you're looking for. And then the way that the protocol works is that everyone will be downloading bits and pieces of a particular file from each other at the same time. So you're simultaneously downloading a piece to your computer, and then you're uploading that to other users. And then you're downloading other pieces, and the client is basically reassembling all of these little software pieces, or these little file pieces, into one complete file. So everyone operates in what's known as a swarm, where they're all downloading from each other, from their peers.
And what was happening here in this lawsuit? What was the act of infringement, and what were the works being infringed?
In these particular lawsuits, they were all adult films, adult entertainment films, and that's where most of these suits are arising from now, is the adult entertainment industry, where a lot of times people are sharing these movies over BitTorrent, and users, thousands of users are downloading each of these films, and the adult entertainment industry is sort of feeling a pinch in their pocketbook. They're not getting as many subscriptions, and they're not selling as many DVDs of their films. So one of the new sort of business methods that they've decided to see some profitability from these movies is to engage in these sort of mass copyright infringement lawsuits against BitTorrent users and try to convince them to settle.
And the defendants here that we're talking about, how many in these mass suits?
These four in the Northern District of California range from a low around 80 to a high around 3,000, but we have seen BitTorrent suits where there have been up to 20,000 defendants.
Obviously, this isn't the first lawsuit seeking to identify BitTorrent users. How does this normally play out when they try to figure out who is doing this?
It's played out in a variety of ways, but as I think more and more courts, and this is the Northern District of California that we're talking about here, but as these courts become more comfortable with this type of litigation, we're starting to see more and more courts refusing to allow these massive lawsuits with thousands and thousands of defendants go forward. Essentially, the way this works is that you can get basic monitoring software to figure out the IP address of people that are participating in a BitTorrent swarm or who are downloading pieces of a particular film. It's identified by a hashtag, so you can figure out who they are and you can at least figure out their IP address. And then in order to file a lawsuit, obviously you have to identify the particular user, and an IP address, while it gives you information about the computer that was used, it doesn't identify the user in and of itself. So the first step in litigation like this is to get the court to agree to allow you to issue subpoenas to internet service providers so that they'll disclose the identity of the computer that was participating in this download. And then from there, you'll have to amend your complaint, which is filed against Doe defendants, and to name the people who are actually involved. The goal of most of the companies and law firms that participate in this type of litigation is to not even get to the step of having to amend the complaint to name the actual users, because as soon as they find out the identity of the users, the goal is to get them to settle.
So in this case, why did the magistrate sever and dismiss?
Well, what we've seen in these cases recently is that there are certain rules that allow you to, number one, to get discovery of Doe defendants' identities, and also rules that relate to who can be joined to a lawsuit as a defendant. So with respect to getting early discovery of the identity of the defendants, you have to show you're not allowed to get early discovery if the discovery that you're requesting wouldn't actually identify the people that you're trying to identify, or if the claims are so weak that they would be dismissed on other grounds. So basically, even if you found out the identities, you'd still lose the lawsuit because the claim would be jurisdictionally defective in some other way. And what these courts are saying is that under the rules of joinder, which is Rule 20 of the Federal Rules of Civil Procedure, they're saying that you can only join defendants to an action if whatever they're accused of doing arises out of the same transaction or series of transactions, and that there's common questions of law or fact that relate to all the defendants. And in these lawsuits, these BitTorrent lawsuits, the courts are saying that the actions of the defendants don't arise out of the same transaction or the same series of transactions. What they're saying is they might be downloading the same film, and the plaintiffs are even presenting evidence that they participate in the same sort of BitTorrent swarm, but the court is looking at that evidence and saying some of these acts of infringements take place up to 6 months apart. So how in the world could you suggest that it's one transaction, one infringement, when someone is not even downloading the file till 6 months later? And a lot of this comes from the nature of the BitTorrent protocol itself, which is that how you define a swarm of users can vary, right? So if you're participating, for example, and you leave your BitTorrent client up all the time, so it's constantly downloading and constantly re-uploading, and then 6 months from now, I was to log on to my BitTorrent client with the same tracker, the same piece of software to locate this file, I'll start downloading from you. But was your action of downloading and uploading the same as my action of downloading and uploading when we're doing it 6 months apart? And what if I finish downloading the film and totally drop out of the BitTorrent protocol without uploading at all, or without continuing to upload before someone else joins the swarm and downloads from you? So the question then becomes, how are all these defendants connected to each other? And the court is saying they're not. So it's not fair to them, essentially, to allow a plaintiff to bring a suit against thousands of defendants.
Okay, now there's also this notion of an IP address not equaling a person that plays out in here. Can you explain that?
Yeah, the court says, well, the court lists, the magistrate judge lists a lot of problems with these suits in addition to the joinder problem. And all of these cumulative problems relate to what the court describes as the unfairness of allowing a lawsuit like this to go forward against hundreds or thousands of defendants. And the IP address identity comes into play there because the court says, look, there are a lot of defenses that any of these individuals could bring, and one of those defenses could be, I'm not the person that downloaded this. And basically your IP address identifies your computer. And you might have been you might have not been the person at home using the computer when this happened. You might have had a guest over, or you might have a family member that was participating in this BitTorrent download, or even you might have an open wireless network, and your neighbor or Starbucks or any company that has sort of an open wireless system would know that's not password protected. You can't really identify the actual user from that information, or you may not be able to.
Has it been discussed, or has there been any sort of notion that the person that the IP address is registered to should share in liability or should have some sort of liability?
We haven't seen a court go that far, but in some of these situations where some of the settlement letters have been disclosed, we've actually seen plaintiffs' lawyers in settlement letters, basically a letter that they send once they get the identity of the person accused of doing the infringement, to try to get them to settle to avoid going to court. And usually these settlement letters will be for several $1,000s, as opposed to statutory damages, which could range up in the hundreds of thousands of dollars if it was to actually proceed to trial. These settlement letters have suggested that the plaintiffs will argue that it's negligence if you don't secure your wireless network and this happens on your watch. Now, no court has gone that far, and in order for that theory to sort of play out, you'd have all the traditional questions of negligence, like a duty, et cetera. But we've seen at least plaintiffs make the claim.
One thing that's interesting here is we know that there has been a copyrighted work that has been infringed. What does the copyright holder do now? Where do they go from here as far as people sharing their copyrighted works on peer-to-peer networks, or BitTorrent specifically?
Well, right. With this court, at least under this magistrate judge's theory, they will be required to file individual lawsuits against each DOE defendant. Now, you can imagine why plaintiffs don't want to do that. It's expensive to file litigation, and then it sort of interferes with the idea of using these sorts of lawsuits and these sorts of settlement letters as a new business model. Not this particular magistrate judge, but another judge in the Northern District of California has actually expressed concerns about the fact that some of these films don't even appear to be produced for commercial purposes anymore. They appear to be produced as a litigation factory. And, the judge said, in light of the constitutional provision that allows copyright, which is to promote the progress of science and the useful arts, it appears that lawsuits like this are basically a massive collection scheme, and they're not promoting the useful arts anymore. Now, that's, of course, one judge's theory on these types of lawsuits, and there have been judges that have allowed these mass suits to proceed. And one judge has even suggested that it's actually to the defendant's benefit because it streamlines the trial procedure to allow mass infringement suits like this. But at least in the Northern District of California, there seems to be a growing movement to suggest that you need to sue each defendant separately. And on a certain level, that makes sense, right? I mean, imagine case management when you have 5,000 defendants. Each one is supposed to be able to participate in depositions. Each one is supposed to be able to participate in any sort of case management conference. Each one will have sort of unique defenses that will result in basic mini trials for each defendant. So if just the administration of court proceedings would be a massive headache.
So on the other side of this, can BitTorrent users continue to use BitTorrent to view copyright-protected works and not worry about being sued for infringement?
No. There's still a good chance that you're going to be sued. There's still a good chance that you'll wind up in a district that doesn't have as developed a body of law as the Northern District of California, and you'll wind up before a judge who doesn't see this sort of mass joinder as a problem. And then you're basically in the traditional position of, is it cheaper to settle than even contest the lawsuit? And if I do contest the lawsuit, what are the maximum damages that I could wind up facing?
That's Michael Dunn. You can read the Law Report article about this case, along with the opinion, the complaint, and other court filings at BloombergLaw.com. We'll post a new podcast each Tuesday. Until then, thanks for listening to the Bloomberg Law Intellectual Property Review.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.